Hi, everyone.
Hello, everyone. Have we admitted all of our attendees?
Looks like they're here.
All right, terrific. All right, I have a green light to go ahead.
Yep, you are good to go.
All right, wonderful. Hello, everyone. I'm Gigi Godwin, President and CEO of the Montgomery County Chamber of Commerce, and it is my pleasure to welcome all of you to today's virtual business accelerator on employer liability for vaccine enforcement, presented by Sarah Nash of PilieroMazza, PLLC. Before we get too far along, I would like to acknowledge that our co-chair of our small business committee that oversees our work on behalf of our small businesses and leads for our accelerator is Cal Atia of Care First. And I don't know if we can spotlight Cal, who's joined us. I know that we have about 150 of you joining us today, and I wanted to make sure we could acknowledge our thought leadership on the board of directors.
Yes, we don't have Cal yet, but we do have Aaron.
Excellent. Then it's my pleasure to introduce Aaron Allen, President and CEO of Contemporaries, who chairs our Small Business Committee and our Accelerator series. Aaron.
She might be still connecting to audio.
That's a possibility. But when she's able to tune in, I did want her to offer a few words of greetings to our attendees, but I'll continue until we understand if she's on. She can't hear yet. Okay, but let's keep going, and then as soon as Aaron can hop on and Cal can, then we will turn over to them. Sarah Nash is a partner in the firm's labor and employment group. And she'll provide an overview of recent legal developments in vaccine and mask mandates and their implications for employers like you, and particularly those of you engaged in the federal sector. And by the way, I want to give a special greeting to all of our federal contractor companies that are members of the Chamber, as well as our VIP Veteran Institute for Procurement grads who've also joined us today. That's a program that we have in the Chamber's Foundation, the Veteran Institute for Procurement. So welcome VIP grads as well as Chamber members. This program, of course, is going to be of interest to GovCon CEOs and their professional staffs who manage compliance requirements for their company. Key learning points today: the Biden administration's actions and their impact, particularly the vaccine mandate on federal contractors, regulations covering COVID vaccine policies, accommodating exemptions to mandatory vaccination policies, state laws, and other employer considerations. If you'd like the slides and the audio from today's webinar, please reach out directly to us and we will make sure that they're made available to you. So we would like to begin with some poll questions for all of our attendees. So are we ready for the poll questions to go up on the screen?
Yep, we're ready.
All right. Our first question is, where is your business located? Are you in A, Montgomery County, B, Metro Maryland, C, Northern Virginia, D, Washington, D.C., or other? Because we have VIP grads in 50 states and 3 territories. So again, welcome to us today. So give us an idea what the answer to those polling questions are. We'd love to know where you're calling in from today. Next question. Does your organization, this goes to the size, number of employees you have, is your next question. Does your organization have more than 100 employees? Yes or no? Ooh, we're seeing our results to the first poll questions. Okay. So again, does your organization have more than 100 employees? Yes. Or B is no. All right. Continuing on. Next question is, do you have a contract that has incorporated Executive Order 14042? That's the Executive Order 14042 concerning the vaccine mandate. Does your contract have this incorporated? A, yes. B, no. C, not sure. All right. We're hoping that people will respond to that so we get an idea of the lay of the land. Oh, I'm seeing a lot of yeses.
Mm-hmm.
And some no's and you know, a couple of not so sure on that one. Okay. Very good. And I think those are all of our poll questions. So just to review, we got everybody in, and did we get a good response on that so we have an idea? And which industry is your company in? Are you a government contractor who's in biotechnology? Are you a nonprofit association, professional services, or other? I'm giving you a minute to think about that and answer so that we get some data on who's with us today. Again, government contracting. All right, good. And the answer is heavy on government contractors, a few nonprofit associations. We have some professional services with us today, and other. All right. So it gives us a good idea of who's with us today. All right, continuing on. So with that, it's truly a pleasure to introduce Sarah Nash, partner, labor and employment for PilieroMazza PLLC. Just to give you a little background about Sarah so that you know the depth and the breadth of the questions that you can ask today. Sarah advises government contractors and commercial businesses on a wide variety of labor and employment issues, including the Fair Labor Standards Act, the National Labor Relations Act, Office of Federal Contract Compliance Programs, regulations, and anti-discrimination law. Her practice includes counseling employers on terminations, labor relations matters, employment agreements, wage and hour issues, and employment practices and policies. Sarah regularly advises clients on compliance specific to government contracting, including offering counsel on prevailing wage laws such as the Service Contract Act, codes of ethics, and equal employment opportunity requirements. Sarah's litigated cases before federal and state courts, including representing clients at arbitration, administrative proceedings, and mediation. She's participated in litigation in a number of practice areas, including labor and employment, administrative procedure, constitutional law, trademark law, and appellate practice. And she also serves as co-chair of PilieroMazza's False Claims Act and Audits Investigations team. She's also a member of the firm's construction industry team, where she focuses on matters arising from the Davis-Bacon Act and prevailing wage requirements. So as you can see, you're in very good hands today. And so with that, I now turn over today's EXCELerator program to Sarah Nash. Take it away, Sarah.
Thanks so much, Gigi. And I saw Erin just joined as well. So hi, Erin. I'm glad that you're able to get back in. And hi, Cal.
Really? Yes, I was having significant audio issues. Yes, lovely to see everyone. Thanks.
And Cal?
Welcome.
Hello, everybody. Yeah, I had some technical difficulties as well, but I'm good now.
Well, we're happy to have you, Cal. Atia is representing Care First, and he is our co-chair, and Aaron Allen with Contemporaries is our chair of our Small Business Committee, under which EXCELerator's program is offered. Thank you very much, Sarah. It's all yours.
Great. Let's dive in. We've got a lot to talk about. And I am a partner in the labor and employment practice at PilieroMazza, but lately I feel like all I do is talk about the vaccine mandate. So we're going to spend the next hour or so going over some of the really interesting developments that have taken over the last At this point, it's really 6 months. There's been things that have been happening in the vaccine world. So we'll talk about those. We'll have an opportunity to answer folks' questions and get into some of the really interesting sort of nuances of the law, some of the question marks out there. There's a lot of gray areas that we really don't have answers to yet, but hopefully I can provide some insight. Thank you so much for answering the polling questions. For that 15% out there, if you're unsure about whether this particular executive order for federal contractors is in your contracts, you will probably learn how to find out by the end of the session. So we'll talk through some common questions and some common issues, and I welcome questions as we go along. If you could go to the next slide, Alexis. Gigi already gave us a great introduction. I'm with PilieroMazza. We have a focus on government contractors, as well as litigation and business and transactions and labor and employment. And so enough about that. Let's dive into some of the good, interesting stuff for the day. As Gigi mentioned, these are some of the things we're going to go over. There are, in particular, I think, 4 pretty interesting Biden administration actions that we're going to focus on. Of course, the chief of most of which is the federal vaccine mandate for federal contractors. We'll also go over specific regulations that are related to these COVID vaccination policies, the big ticket items on accommodating for exemptions. This has been a huge headache for a lot of companies out there as they try to navigate the ADA and the Title VII, which is the law that specifically addresses sincerely held religious beliefs. We're also going to talk a bit about state laws out there. Generally, federal law is going to control because of what we refer to in the legal world as a preemption doctrine. However, there have been some states out there that have indicated that they will not back down from a fight if needed. And so we'll talk about what those states are, whether other states will join them, and how to navigate some of those questions if you are operating in one of the states that might have a law that is contrary to the federal contractor mandate. And then lastly, we'll talk about some overarching considerations for employers as you try to navigate these requirements. Next slide. So I mentioned that there's been about 6 months of really interesting develops out of the Biden administration. One of the earliest actions as it related to vaccinations was in July this past summer. The Biden administration, that's when they first created the Safer Federal Workforce Task Force, which is a mouthful. So from now, I'm just going to refer to it as the task force. So this task force was initiated in order to come up with model safety principles for agencies out there. A lot of you probably saw some worksite access requirements being circulated in response to this particular action. What the Biden administration said is they announced that agencies would need to implement basically testing or vaccination requirements for their work sites. In other words, if you're going to be coming onto a federal facility, you will be required as either a federal contractor employee or, a federal employee to either be vaccinated or to be able to show a negative COVID test. I am guessing that a lot of your contracts out there and the facilities specifically have circulated a lot of these requirements. And specifically, employees, if you haven't gone through the process, I'll explain it briefly. Whenever you go on site, there's an obligation to sign an attestation form. And this form either confirms that you have been vaccinated fully, which is, 2 weeks after the last shot, the second shot in a Pfizer or Moderna shot, or the first shot in a Johnson & Johnson shot. So assuming that 2 weeks have passed since that last shot, you are fully vaccinated and are able to attest that you have been fully vaccinated. If you have not been fully vaccinated, there is an alternative whereby you need to be able to demonstrate either by showing a biweekly or a weekly, so something that's happened either within the last week or within the last 72 hours, a negative COVID test. There are different rules that apply to vaccinated and unvaccinated folks. Vaccinated folks, don't necessarily need to wear a mask when they're indoors. The masking requirement for those individuals only applies if there is an area of high or substantial transmission rate. And for the unvaccinated folks, there is an obligation to wear a mask regardless of the transmission rates in the area and certain restrictions on travel. So some of you out there might be wondering why I'm even talking about this. The big star of the show is obviously the federal contractor mandate. That said, just because the federal contractor mandate came out recently in September, and as we know, it's gearing up to go into full effect this January 18th. Just because that goes into effect does not erase these initial worksite access questions. Whenever you're considering these issues, you need to really consider them side by side. On the one hand, you have what are the specific worksite requirements that are imposed by the agency that you're servicing. And on the other hand, you have these contractual obligations that attach under EO 14042. And so it's important, I'm going to reference this throughout. There are a lot of rules that apply to the federal vaccine mandate, that contractual obligation, but they don't necessarily take into account what your specific facility might be requiring. So it's important to keep in mind that there are a few overlapping requirements, which is making this process much more complicated than it needs to be, but it is the way it is. So I'm going to hopefully give you some tips for how to navigate it and make sure that you fully understand the requirements that apply. If you could go to the next slide, Alexis. So more recently, the Biden administration on September 9th expanded on these previously voiced requirements. And in this September 9th announcement, they made some really big updates about the Biden national security strategy and how the administration plans to combat COVID. This sent major shockwaves through the industry. As I've referenced, Executive Order 14042 is the order that specifically requires vaccinations for federal contractors and ongoing safety protocols. There's actually a separate executive order for federal employees. They're subject to the requirement as well. Their requirements are on a different timeline from the federal contractor requirements, though. They're technically supposed to be fully vaccinated by November 22nd. If any of you out there are quoted this November 22nd date, it does not apply to contractors. Sometimes agencies or individuals conflate the two, but really that is strictly the federal employee side of things. So I'm going to talk in more depth about 14042 and some of the requirements, but initially I'm just going to get through some of these other announcements that the administration put forward. As you may also know, there was a second requirement that applies to private industry folks, and it's only for companies that have at least 100 employees. For those companies, OSHA recently issued a ETS, that's an emergency temporary standard, where they announced that companies with 100 or more employees will have an obligation in the coming weeks to either have a mandatory vaccine policy or have a mandatory vaccine policy with an exception for those who choose not to get the vaccine who must be tested. I'll talk more about this on a future slide. OSHA released this rule essentially last week. It was very much anticipated throughout the industry. It has already been stayed by the Fifth Circuit. I'll explain a little bit more of what that Fifth Circuit decision actually means. Right now, not much, but eventually we will have a better idea of whether this OSHA ETS is going to go into effect, because the initial dates for compliance are coming up rather quickly, assuming that it does get past the courts. Companies have an obligation to comply as soon as December 5th. So the deadline's coming and we need some answers from the courts on whether it's actually going to go into effect. There are a couple other administrative actions with respect to paid leave. That is addressed by the OSHA ETS. I'll address that once we get to that slide, and requirements for healthcare workers at Medicare and Medicaid hospitals. Next slide. So let's dive in a little bit to the federal contractor mandate for vaccinations. These, for the most part, are governed by FAR 52223-99. There's also a DFARS provision, which is a slight iteration, the DFAR specific requirements. For the most part, though, for your civilian-based requirements, you're going to see the FAR provision. This is a provision that essentially incorporates the executive order and the task force guidance into a particular contract. Covered contracts you will know if you have a covered contract when this clause is incorporated. And my guess is a lot of you explained that you have had this FAR clause incorporated into your contracts. Agencies have been doing it at a very quick pace. I have seen a lot of these over the past few weeks, and most agencies are not waiting until a new option and not waiting for a new contract. They are incorporating these requirements now. And the guidance allows them to do that. Under the EO that Biden issued and the guidance that the task force has been rolling out sort of on an ongoing basis, agencies had an obligation to, as of October 14th, incorporate this new FAR clause into any new, renewed, and extended contracts. However, they had the option to incorporate it sooner into those ongoing contracts. And as I mentioned, they've been doing this at a quick pace. Once this FAR provision is incorporated into your contract, some fairly rigorous requirements begin to attach. And as you likely have heard by now, one of those big requirements is going to be a requirement to get your employees who are working in connection with or on that contract vaccinated. It's a little bit more nuanced than that, and I'll go over specifically who is covered once this is incorporated into your contract. But basically, if employees are working in support of a particular contract, they need to be vaccinated. There is no testing alternative available under the federal contractor mandate. However, there are two very distinct exemptions that might apply, and those relate to accommodations for either one, a medical reason, or two, a sincerely held religious belief. I will get into some additional details further on in the presentation about how to determine if someone's asking for an ADA or a Title VII accommodation. But it's important to note that those are the only two exceptions. There are no other exceptions to employees who are covered. They must get vaccinated by this January 18th, 2022. Apologies for the typo in that slide. 2022 is the deadline. This happened very recently. Until about a week ago, the deadline was December 8th, when the Biden administration released the OSHA ETS. They kicked it back a few weeks, though, to make it a little bit more consistent with the OSHA requirements. So let me talk a little bit about who specifically is covered under these requirements. It's going to address really three different types of your employees. First, it's employees who are working directly on the contract. Those are your employees who are specifically performing the work in the performance of work statement. The second group is going to be your employees who are working in connection with a covered contract. That's going to be your overhead, your HR, your payroll, anyone who's providing services that are really indispensable on this contract. They're not necessarily providing work directly in support, but they're providing work that without which the contract would be unable to function. And then lastly, you have a third group of people. Even if someone is not working on or in connection with a contract, if they are working at the same work site or the same facility as one of those two other groups, if someone who's working in direct directly on the contract or in connection with the contract, if someone's working alongside those individuals, they also are considered covered employees and must be vaccinated unless they fit one of the two exemptions. This means that the requirements do not necessarily apply to all of your employees. If you have employees who really have nothing to do with a federal contract and they're not working on site with employees who are working on or in connection with that contract, then they do not need to get vaccinated. This often will be the case with your remote employees who are maybe not working on or in connection with your contract. There is a documentation requirement that is different from the attestation that I described falling after the July worksite access issues. Unlike with the worksite access questions, it is not sufficient for employees to attest that they have been vaccinated. Rather, companies need to review a vaccination card or an equivalent record from a healthcare provider. So as companies, you need to be requesting that employees submit a copy of their vaccine card. And when you're asking for this information, it's important to know that this is something that you might be audited on in the future. So you either want to keep copies of these vaccine cards or have a system sort of like you would with when reviewing I-9 information. Basically have a form that, you know, confirms the date that you reviewed their card, who reviewed it specifically, and just have that on file in the future in the event that there is an audit down the road. Bear in mind that vaccination status is protected health information. This is important information that you cannot just let anyone have access to. It should be shared on a need-to-know basis only. Sometimes in unique circumstances or rare circumstances, we've seen some agencies or prime contractors asking to see their subcontractors or the prime contractor's vaccination information. This is not required by the task force guidance. However, often if an agency asks for it, they're entitled to it. And so just make sure that you have employees' permission to share this information with third parties prior to sharing it, because again, it is protected health information. Another requirement under these FAR obligations is to flow down the vaccine mandate to your subcontractors. I'll note that it's not all subcontractors that you need to flow down this information to, the FAR clause. It's just going to be those subcontractors who exceed the simplified acquisition threshold, currently $250,000. It's not that hard to get to that number over the life of a contract, but if you do have subcontractors who are just performing odds and ends here and there, likelihood is they would not need to be incorporated, or you would not have to flow down the requirements. There's also an exception for vendors. So what is described as a vendor? Really, a vendor is going to be anyone who's not performing work directly on your contract. A vendor is someone who you would not typically flow down those FAR requirements to them for other requirements. So vendors need not be vaccinated. However, the minute that you have a contractor who's performing work directly on the contract, they are considered a subcontractor and are required to comply with the vaccine mandates. There's another requirement under the federal contractor mandate, and that is to appoint a workplace safety coordinator. This coordinator is responsible for monitoring community transmission rates. There's actually a weekly obligation written within the guidance to be reviewing these transmission rates. They provide a website that you can go and check. I believe it's through the CDC to make sure that transmission rates have not changed. And those transmission rates will determine your masking and social distancing requirements. Under the guidance, it's not just about vaccinations. It also deals with masking requirements. If you're in areas of high transmission rates, there is an obligation, vaccinated and unvaccinated alike, to wear masks, and for unvaccinated folks to socially distance where possible. So these are all the requirements that are imposed. I will talk a little bit about how some of the questions we've been coming across as we deal with these issues. But in the meantime, Alexis, if you could go to the next slide. Great. So over the last, since October and really between September 9th when Biden first announced this directive, we saw a lot of flurry of activity throughout all of the agencies. This is just a few examples of agencies that started to incorporate their own deviation of the FAR provision. As you can see, at this point, it really should be all of them. You've got the VA, Homeland Security, NASA, all updated their FAR deviations really quickly October 1st. You had DOJ shortly thereafter, Department of Commerce. Again, this is not an exhaustive list, but all of these agencies were tasked with drafting their own deviations. And if you were to look, you would notice that really there is a broad scope of how they decided to do this. And as I mentioned earlier, there's a lot of discretion afforded to agencies in terms of how they want to apply these requirements. While the FAR clause only needs to be incorporated into service and construction, those types of contracts, some agencies have determined to incorporate it into contracts for products. Some have determined to incorporate it into contracts that do not meet the simplified acquisition threshold. And so there's a lot of discretion, and agencies, for the most part, have taken a fairly heavy-handed approach. They are applying this where they are able to. Really one of the few exceptions is that it does not apply to contracts performed outside of the United States. So if you have contracts that are outside of the US or its territories, the requirements that do not apply. On the other side though, if you have a product contract, if you have a contract that's really not services, there's no guarantee that your agency won't try to incorporate it into your contract. Agencies are also incorporating these in a sort of unique way. They are doing it through, for the most part, bilateral modifications. And this, as you know, is a modification that requires basically the contractor's agreement in order to proceed. So they will send a modification to the contractor, and they will say, get this back to us in the next week, sign that you approve. A lot of these bilateral mods have included waiver language that essentially says that the contractor agrees that there's no additional cost to the contract due to this change. Where that has been incorporated into your contract, it is not entirely clear how best to respond to that. As you know, as if you've been dealing with the administration of this program, there are potentially lots of additional costs due to this vaccine mandate. First of all, you have to pay for the time that employees are going to get the vaccine. There are potential recruiting costs if you are unable to keep your entire team due to the fact that some folks do not want to get vaccinated and do not want to or do not qualify for one of the exemptions. There's this additional requirement to have a coordinator who is going to be responsible for performing those job duties. There's just a lot of potential costs that come into play that some agencies are acting like don't even exist, which is very frustrating. Other agencies are being a lot more responsible about understanding that there are potential costs here and encouraging contractors to communicate with them about what they are. If you see that waiver language, ideally, you could convince your CO to take it out because it could limit your ability to get an adjustment in the future. Some COs have been particularly stubborn, though, and are unwilling to take out that language. And at that point, as you know, agencies can terminate for convenience when they feel like it. And some agencies have indicated if they get any pushback whatsoever from incorporating these FAR provisions, regardless if it's really just about the waiver language. They have really been threatening to, fine, we'll find someone else who wants to do the work. So I suspect that this is really an issue that's right now, that's a big issue now that will change over the next few months as more and more folks get vaccinated. But figuring out what the cost is really one of those big questions that we just don't have all the answers to. And I suspect we really won't know until January 18th when that initial deadline really has come to be able to figure out what next steps are. Next slide. So it's not clear entirely what the penalty for noncompliance is. Initially, the guidance did not offer really any explanation for what the consequence of a contractor not complying with these requirements was. Obviously, there's a potential for breach of contract. In the FCA world, the False Claims Act, there's this idea of implied certification. As you can imagine, an express certification is where a contractor specifically certifies that they are compliant with something. A good example is Davis-Bacon Act. I certify that I have paid my workers X dollars over the past week. That's an express certification. On the other side of things, you have an implied certification, and an implied certification is basically by submitting the invoice in and of itself. You are impliedly certifying that you are in compliance with your contract. If you are submitting that invoice and your contract has that FAR 52223-99 in it, there's this idea that have you impliedly certified that you are compliant with that federal vaccine requirement. If you certify that you are, but you have folks who have not been vaccinated and do not qualify, for one of those exemptions, there's a potential FCA issue. Last week, all of my weeks are blurring together, but I believe it was last week, the guidance issued some additional Q&As, and I encourage you to go look at their website. They've got all of these Q&As, some that are specifically geared towards federal contractors. And they included a couple of explanations that hopefully will give contractors the ability to breathe a sigh of relief as you're trying to implement these requirements. One of the explanations that they wrote included this: where covered contractors are working in good faith and encounter challenges with compliance with the vaccine mandate, the agency contracting officer should work with them to address these challenges. If a covered contractor is not taking steps to comply, significant actions, such as termination of the contract, should be taken. What this signals to us is that if you don't have all your folks vaccinated on January 18th, it is not the end of the world. As long as you are working in good faith, what does that mean? Maybe have a policy, have communicated to employees what the requirements are. As long as you are working towards that goal, this guidance, which is incorporated by reference into the FAR clause, should satisfy the requirements. However, there's another caveat there. The guidance in another section also explains that any agency may determine that a covered contractor employee who refuses to be vaccinated in accordance with the contract requirement will be denied entry to a federal workplace, consistent with the agency's workplace safety protocols. This indicates that even if the contractor is technically in compliance by working in good faith towards getting their entire workforce vaccinated, even if they're working towards that end, if an agency facility has a requirement that folks be vaccinated, or that folks be vaccinated or qualify for one of the two exemptions, that's not going to be a defensible excuse for why your contractors can't get on site. So it's important to really understand carefully what the facility requirements are, because if your CO ends up saying that anyone who's on site needs to get vaccinated come January 18th, and we don't care if you're working in good faith, they're not allowed on site otherwise, you need to keep that in mind, because otherwise you could run into issues with your workforce. As I mentioned, the January 18th date is a recent development. Until last week, contractors had been given December 8th. And so a lot of policies out there probably still have December 8th as the deadline for compliance. You don't necessarily need to give employees additional time to get the vaccination, but it's an option that you have. So if you do want to wait until that just January 18th deadline, by all means, that is available to you. And again, arguably the guidance also allows you to even go a little bit later than that for folks who may be hesitant to get the vaccination. Next slide. So I've gone over the vaccine requirements for federal contractors. And as I mentioned, there's also this OSHA ETS. And the OSHA ETS, for the most part, if you're covered by the federal contractor mandate, you do not have to worry about this. I say for the most part, though, because it's really not a blanket exception for all federal contractors. It's a blanket exception for workplaces that are subject to the federal mandate requirement for contractors. So if you have a work site that doesn't perform work on or in connection with a contract, then, and you have at least 100 employees, then you're going to be subject to the OSHA ETS. So it's important to understand how these two laws potentially overlap. Again, if all of your workforce is covered by the Executive Order 14042, you really don't have to worry about this. But it's worth going over. Some of you, it looks like you have those 100 and plus employees and may have work that's not necessarily 100% federal, so you need to understand how these requirements apply. The deadline for initial compliance with the ETS is December 5th. That is a little bit different from the deadline for when testing needs to start taking place. What does this December 5th deadline entail? It's going to be any contractors who are, any companies who are covered by the requirements of the ETS must have a policy in place by no later than December 5th. Again, the Fifth Circuit has a stay out there right now, but if you want to make sure that you're in compliance and that stay for some reason gets lifted, we're running out of the time between now and when the deadline is initially going to hit. So it's important to be thinking about these things. There is also a requirement that kicks in on December 5th for companies to provide an additional 4 hours of leave for employees to get vaccinated. This is not in leave or requirement that can be satisfied by pre-existing PTO or sick leave. It is additional leave that the administration has determined is necessary in order to get employees vaccinated. Unlike the federal contractor mandate, the ETS does not apply to employees who are working remotely. It's only going to apply to those individuals who are working where others are present. So if they're on the work site and others are on the work site, the ETS will apply. Now I'll talk a little bit about the case that's out there. There are actually a lot of cases. There have been cases filed against this OSHA ETS in every circuit but the 10th Circuit. And so when that happens, there's essentially a lottery across the circuits for them to determine who gets to hear this case. To avoid having every single circuit court issue an opinion on this, they engage in this lottery system. If the Fifth Circuit wins the lottery, we already know how they've held. They've determined that this ETS is not enforceable, and they've issued a stay on that basis. So if some other circuit wins the lottery, they are going to be responsible for determining what their opinion of the ETS is. My guess is it ends up before the Supreme Court. and we have an issue, and before we can actually have a full decision. So we'll see what happens there. In the meantime, as I mentioned, that December 5th deadline is coming. It will be kicked back, though, if we don't have an answer from the courts before then. Next slide. So it's good to have just an understanding of some of the regulations out there covering vaccination and COVID. Often a lot of questions we'll receive in our practice group are, is it lawful to require employees to get vaccinated? Can I fire someone who decides not to get vaccinated? And these are questions that there's actually some history here and there's some context. So it's good to understand some of that context for when we're looking at these issues. So prior to the COVID pandemic, it was actually not uncommon for employers to require employees to get vaccinated. And the most common vaccine requirement that you would see is for, the flu, seasonal influenza. And so it's not an unprecedented idea to have companies requiring their workforce to get vaccinated. You see this in the school system as well, right? Vaccinations are a requirement if kids want to go to school. And that's from a public health perspective. And so the agencies out there and the Federal Regulatory Authority have, a lot of them have weighed in on this issue. We've heard from the EEOC, we've heard from OSHA, we've heard from DOJ. All of them are saying that COVID vaccinations can be mandated by employers. And at least the EEOC's position at this point is that this pandemic, COVID, poses a quote unquote direct threat to health in the workplace. And in the EEOC world, when you meet that direct threat standard, there are some additional tools that companies have to protect their workforce and to ensure a safe working environment. And so because COVID meets that direct threat, there are some additional tools, i.e. Asking employees about their vaccination status that you might not necessarily have if this was not determined to be a direct threat. And so because of the risk that the pandemic has imposed, these employers are permitted to implement enhanced safety measures, including COVID vaccination mandates, and asking about whether employees have symptoms of COVID and whether they have been vaccinated against COVID. Next slide. So OSHA has also weighed in beyond just the ETS. They've generally issued guidance about COVID more generally, and there's a couple things that go hand in hand with employer obligations under sort of OSHA requirements. One is you have a general duty under COVID to provide a safe working environment free of workplace hazards. This can include encouraging vaccines because COVID is considered a workplace hazard. Because it's considered a workplace hazard, there are also certain reporting requirements when an employee is hospitalized due to receiving COVID from the workplace, or when there is a fatality associated with COVID that was contracted in the workplace. There are certain OSHA reporting obligations. And so OSHA is also weighing in. They were weighing in well before this ETS that came out last week. Next slide. One of the biggest issues, and I think a big part of why this is falling into the labor and employment rubric, is this question of accommodating employees and meeting one of those two exemptions that are permitted under the vaccine mandate. And when I refer to the vaccine mandate, just for the rest of the presentation, I'm just going to be talking about that vaccine mandate for federal contractors. Generally, I'm not going to be referring to the ETS, or if I do, I will make sure to specify what I'm talking about. But under the vaccine mandate for federal contractors, there are two exemptions permitted. There's a medical exemption, which falls under the Americans with Disabilities Act, and there's a sincerely held religious belief exemption that falls under Title VII, as I mentioned. And unless you meet one of these two exemptions, if you refuse to get one of the available COVID vaccinations, then you are not permitted to continue to work on a covered contract or to work alongside those who do. And so it's a pretty steep penalty for failing to comply. And we've seen a lot of these requests over the past few weeks of employees asking to be covered by one of the exemptions. I will mention that when you ask an employee who has chosen not to be vaccinated why they have chosen not to be vaccinated, this can elicit some information about a disability or genetic information. Genetic information is governed by GINA, so you want to be careful. And generally with disabilities, you don't necessarily want to ask employees about their disability unless they need that accommodation. So you want to tread lightly. Where I'm seeing this happen most often is with new hires. So a lot of companies out there are wondering how they can go about imposing a vaccine requirement on their new hires. Generally, what I will recommend is that you make a conditional offer. Well, first, you would advertise the position as vaccine mandated, unless an employee has a need for a reasonable accommodation. So I'll have that on the initial job advertisement. But make an offer of employment contingent on getting vaccinated. Generally, you do not want to ask employees prior to that contingent offer whether they have been vaccinated, because it can elicit that information that gets you into ADA world that you really don't want to talk about before you've made a conditional offer. So there are some ways to do it. I'm happy to talk about those if you really feel strongly that you want to know before you make the offer. You just got to be careful to avoid getting some information about disabilities in the process. I mentioned that there are no exceptions to who is covered if you're working on or in connection with a covered contract or working alongside those are. There is one mini exemption, but it only buys you some extra time. It does not ultimately get you out of the requirement. The administration wrote into the guidelines a 60-day exemption for urgent mission critical need. This means that your CO or the agency can specifically give you basically a 2-month pass if you have employees who are unable to get vaccinated before the January 18th deadline, and it serves a mission critical need. But even in this circumstance, it does not get you out of the requirement entirely. We've seen this in some contracts. You have maybe there's one guy who can do this work, right? He's the only guy in the industry who is able to do what the government needs him to do. And he is unwilling to get the vaccination. Maybe he doesn't have a medical need and he doesn't have a religious need. Let's say it's purely political. In that instance, he could get 60 days, but he's not going to get a pass. Okay, next slide. I'm going to get a little bit into the specific accommodations now. So the first accommodation is that ADA accommodation for individuals with disabilities. A disability is that person's own condition that somehow prevents them from getting the vaccine. When you are asking for employees accommodation needs, when it comes to the ADA disability, really good idea to get a doctor's note. You're not a doctor. I don't know everyone on here. Maybe some of you out there are doctors, but probably if you're listening to this webinar, your job is not to evaluate your employees' medical conditions and needs. In that case, it's great to be able to point to this person's licensed medical professional as being the person who has determined that they should not get a vaccine. Usually that's enough. I will say there have been a few instances that we've seen over the past few weeks that really require a little bit more attention other than just rubber stamping a doctor's note saying that the employee should not get the vaccine. I'll give one example. If the doctor says that the employee well, let's leave the doctor out of it. Let's say the employee specifically says that they have previously had COVID, so they don't need the vaccination. That is not sufficient. That's not going to satisfy the ADA disability requirement. And the reason is that the guidance specifically says that having previously had COVID is not a good reason not to get the vaccine. So that is not something that you can rely on if your employee posits it as a possibility. There's an exception for some employees in Texas that I'll address later, but for the most part, if your employee says, I don't need the vaccine, I have a medical exemption because I already had COVID, that's not going to fly. You also want to make sure that you read the doctor's note and read specifically what the employee is not able to do. Some notes, for example, might say this, my patient can't engage in gene therapy. If that's the case, you don't necessarily want to accept that. COVID testing or COVID vaccination is not gene therapy, and so you just want to make sure that it's accurate. And as you are evaluating these ADA accommodation requirements, as you would with any accommodation requirement, generally you're going to want to engage in an interactive process. What's an interactive process? It's exactly what it sounds like. You just want to engage with the employee requesting the accommodation, have a conversation, talk to them via email or in person or, over video chat to talk with them about their needs and talk to them about how you might be able to accommodate their needs. When it comes to ADA accommodations, the company does not have an obligation to provide an accommodation where it creates an undue hardship on the company. Exactly what an undue hardship is a moving definition. But generally, it means something that's going to endanger your employee or those they work around, or create an additional cost that the company simply can't abide by. With respect to COVID vaccinations, there are often a lot of accommodations that employees might be able to participate in that satisfy the ability to keep employees safe, but not requiring this employee to get vaccinated. For example, if they're a remote employee, really there's not much else that you need, right? They're not coming on site, they're not working alongside others, they're relatively safe in their home, and others don't necessarily need to be working alongside them and have a higher chance of contracting COVID. Weekly testing or biweekly testing has been another alternative. Again, there's no requirement. I don't know if I've mentioned this actually, but there's no requirement for individuals who meet an exemption to get tested unless it's a worksite access requirement. If these employees are going on site, then at a federal facility, it's possible that federal facility will have its own testing requirements. And as I mentioned early on, just because the federal mandate is out there doesn't mean that those initial worksite access requirements disappear. Those are still in play. So you very likely will have employees still attesting when they go on site that they've been vaccinated or producing a negative COVID test from either the last week or the last 72 hours. Okay, so that's ADAs. I think the next slide is going to be about religious accommodations. If you could help us out, Alexa. Perfect, thank you. So the next accommodation is for sincerely held religious beliefs. And this is the exemption that's given companies a lot of headaches because it's not really a bright line rule for when you can provide employees with a religious exemption. I'll go over the way that Title VII evaluates these, and then I'll talk about how it interacts with the vaccine mandate. Generally, when an employee submits a request for a sincerely held religious belief, the company has an obligation to presume that the belief is sincere unless there is an objective reason to question that the belief is sincere. So, for example, if this employee has been talking for the last 6 months about how you can't believe that the Biden administration is requiring the vaccine, and this is clearly a violation of employees' constitutional rights, and this is, you know, they're just testing on the American workers, and just things that indicate that it's a political objection, that might give you a objective reason to question that this employee, who's now saying they have a religious belief, has a religious belief. Just because they have a political belief, that doesn't necessarily mean they can't have a religious belief, but that might be a red flag as you are evaluating whether this is a sincerely held religious belief. Another practice that we've seen a lot of is employees downloading basically cut and pasting from internet websites ways that employees can seek a religious accommodation. So when you're seeing employees cutting and pasting from a website, maybe that's an indication that you need to ask some follow-up to ensure that they're not just looking for an out from getting the vaccine. It is perfectly reasonable, once you have a objective reason to question an employee's belief, to ask follow-up questions. There are a number of questions that are fairly typical when it comes to certain types of religious exemptions. One of the common religious reasons that employees say that they do not want to get the vaccine is because it is tested on fetal cells. So some follow-up questions might be, do you get other vaccinations? Do you get other medications that are tested on fetal cells? How long have you had this belief? Just questions really aimed at figuring out whether this is truly a sincerely held religious belief. And the reason that it's important to look at these a little bit more carefully and not just rubber stamp them is really twofold. On the one hand, you don't necessarily know how hands-off your contracting officer is going to be. There have been some COs and agencies that have requested to see employees' accommodation requests. And so if your CO senses that you're just rubber stamping these, they might be none too pleased. Also, down the road, in the event that there is an audit of the company, you want to be able to point to, you know, your religious accommodation file and with a straight face say, yes, we evaluated these and we found them to be sincere. A lot of questions we get relate to, how do we know if something is a sincerely held religious belief? And again, there's no bright line rule for what is or what isn't. But I will say that generally, religious beliefs are going to be moral or ethical beliefs as to what is right and wrong. And these are beliefs that are held by the employee with the same sincerity as that of traditional religions, akin to that of believing in a God. So just because an employee says, well, I don't know what the side effects are, so I don't feel comfortable, or I don't like putting things in my body that I don't have agency over. Those aren't necessarily going to meet that religious belief threshold. But again, ask questions, engage in that interactive process. Typically, this is supposed to be within the contractor's purview. The guidelines specifically say that it is the employer's responsibility to determine whether an employee meets, you know, one of the two exemptions. And so it's your job to figure out whether you think that this would satisfy. And so that discretion I really should give you the ability to make these decisions. Next slide. Okay, so I went over a little bit earlier that there are some state laws out there that make some contractors' lives a little bit more complicated than they really need to be. Generally, preemption is going to mean that the federal law supersedes the state law. So if you have a federal law that says employees are not allowed to, use the stairs. They have to use the elevator. And you have a state law that says employees have to use the elevator. Generally, the federal law is going to control because that's just the way our Constitution works and that's the way federalism works. Out of this vaccine mandate, however, there have been a handful of states that have issued laws and have not acknowledged that federal preemption would give the federal law the benefit of the doubt. Specifically, Montana is a great example of this. Montana issued a law that prohibits employers from denying employment or discriminating against employees based on their vaccination status. In Montana, you're not even allowed to ask employees what their vaccination status is. As we've discussed, this is a specific requirement under the federal mandate. Generally, our response would be like, well, that's fine, federal law preempts, we have to comply with, the federal requirement. There are a couple of quirks in the way that this law has been implicated or imposed that don't necessarily give us 100% certainty that that's how Montana will see it. First of all, Montana came out with a memo that basically says our law controls and you need to comply with it. And you can't, they specifically said the federal mandate for federal contractors does not supersede Montana law. So unfortunately, they are not backing down from that position for now. Meanwhile, if you've read the guidelines, you know that they also say that the federal guidelines supersede state law. And so this puts contractors in Montana in a particularly uncomfortable situation. I suspect we will have an answer in the coming weeks and or months as to how the courts will view this issue, but it is one of those big question marks right now. Florida does not currently prevent companies from requiring employees to provide documentation about COVID vaccination, but it does prohibit businesses from requiring customers to provide that documentation. DeSantis has indicated that he is trying to impose a law that would prevent companies, employers from requiring vaccination status of his employees, but that has not happened yet. We might see something out of Florida in the coming weeks, so it's good if you have folks there to keep an eye on it. Texas, like Montana, has imposed a rule at this point that basically requires 2 additional types of accommodation when evaluating employees' requests for an exemption from a mandate. Texas does not specifically prohibit vaccination mandates, but again, it includes these 2 additional accommodations. One is for an employee who has previously recovered from COVID-19. As I mentioned earlier, the federal contractor requirements specifically exclude prior recovery from COVID from the acceptable exemptions. So here's an example where Texas law specifically requires an exemption for recovery from COVID. That is a inconsistency between the federal and the Texas law. And we really just need to know from the courts, it looks like, how those 2 inconsistent requirements will be applied. Texas also requires a accommodation for someone who objects to vaccination because of personal conscience. This is much broader than that sincerely held religious belief, and so it also throws an additional monkey wrench into trying to figure out how to apply these requirements in the state of Texas. Finally, not all states have imposed limits on vaccinations. In Santa Clara, California, employers are required to obtain a record of vaccination, or they could face a $5,000 a day fine. So the moral of this story is it's really important to understand your state and local requirements, because it's possible that they could impose different requirements or somehow interact with the federal requirements. I think that's the last slide, and so we can certainly address some questions if there are any Oh my goodness, we have a few questions. I apologize that I wasn't able to address them as I went along. But let's see if let me go over some of them now. And certainly if you have additional questions that have come up over the last hour, I'm happy to address them. Let me see if I can maximize this so that I can be a little bit more consistent with the way I address these. Okay, so one of the questions we have is, let's see. What protections are in place for employers if an employee turns in fraudulent paperwork? At this point, you do not have an obligation as companies to police your employees' fraud. If you have reason to believe that a vaccination card is fake or fraudulent, for example, there was news coverage a few months ago about a number of vaccine cards out there that had typos. They spelled COVID, I think, 4 different ways. I would flag that, right? So if you have reason to believe that the employee has engaged in fraud, don't let them get away with it. Be consistent with your policy, hold them accountable. But otherwise, recently we had a question from a client who said, am I supposed to double check the number on this vaccine card? It's not consistent with some of the other ones I've seen. And I don't think that that's a requirement. Really just do what's reasonable, and that should be sufficient. Okay, let's see. This question says, we are a subcontractor on a state contract. Great. Our prime contractor is also a federal contractor on other contracts. All the work we do with the prime contractor is virtual, so remote, I guess. The prime contractor is requiring that we comply with the vaccination mandate with our own employees/subcontractors. Is that consistent with our understanding of the directive? That is not entirely consistent. If you are not performing work on that federal contract, then there is really no requirement under the FAR clause that companies comply. That said, there could be other mechanisms within your contract with your prime contractor that do obligate you to comply. Because you're working virtually, though, I would imagine that this is very separate from their worksite requirements. And I would encourage them to point to where in their contract they have the authority to require this. Some of this is going to come down to bargaining power, right? Because if you have a federal contractor who wants, just for the sake of consistency, to have all of their subs, regardless of whether it's on federal or state work, comply with a certain policy, then they can do it. But again, make sure that they can do it contractually. Another question. One of our agencies has modded our contract whereby we absolve the government of any liability associated with the COVID requirements. How do we respond? I've seen this in a few instances. Sometimes it's coming directly from the agency. Sometimes it's coming from Prime. Again, it really comes down to bargaining power. Are you able to push back and preserve for yourself maybe the ability to submit a claim in the future? I will add that at this point, we really don't know how claims will be handled by the agencies. At this point, I think we're a little bit early in the process to fully understand what the costs we're looking at. So there's not a lot of case law out there. There's not a lot of experience with the Court of Federal Claims or with the Contract Board of Contract Appeals. So we just need to wait and see. But generally, yeah, I'm really nervous when I see those complete waivers as well, because it lets arguably the government get off the hook without any costs. But unfortunately, it's something that they can include, and if they are going to threaten taking away the contract if you don't sign off on it, that's really something you have to weigh. Can an employee that has an exemption be barred from an agency's workplace? In most cases, agencies are not barring employees who have an exemption. That said, I have seen a few agencies who said, we don't care what the reason for why someone's unvaccinated, could be a really good reason for medical reasons. We still don't want them on site, and they're entitled to do that. And so it's unfortunate, but often the reason that they're doing it is because of the nature of the work that they're performing, or the type of how close employees are working together, whether they're working with populations that are vulnerable. That might factor into some of the decision making there. And again, it's not typical, but it is something that I've seen. So in that case, you might have to let your exemption folks know that you're unable to continue to put them on that contract or employ them. Again, there is an exception to an accommodation for an undue hardship. And when your agency is saying that no one can come on site who's unvaccinated, that qualifies as an undue hardship that you're unable to accommodate. Someone is notifying me that they thought that the Sixth Circuit had been selected for the review. That could very well be accurate. I have not seen that news yet, but if that's true, we have some interesting, and this is with respect to the OSHA ETS. Thank you for bringing that to my attention. I have not done I've been running around today a little bit, so I haven't done my typical news dive, but if that's the case, we should have an answer fairly soon. Let me see this next question. This is someone asking about whether we should ask for some additional detail around the medical condition up front to reduce the back and forth. Sometimes that's useful. What we've seen and what the federal workforce, like what the agencies did for their own workforce, was to include some initial questions for the doctor to fill out to help guide them. I'd say this is less important for the medical, just because when you have a doctor's note, that's a really easy reason to say, listen, I'm not a medical professional, but this doctor says you can't have it, so that's good enough for me. We found it to be very useful with the religious accommodation issues to have those additional questions, just to evaluate how long the employees held the belief, whether they've gotten other vaccinations, whether they use other medications that are similar, and that might put you on the right trail. Again, there's no harm in going back and asking those questions. It just might save you some time. This question asks, we are a federal contractor with less than 100 employees, and the majority of our employees work outside. We have some employees who do not go on site on these contracts. Are these employees mandated to get the vaccine? Assuming that your contract has incorporated the FAR clause 52223-99, it really doesn't matter where your employees are working. If they're working on or in connection with that contract, there is an obligation for them to get vaccinated unless they qualify for one of the two exemptions. So unfortunately, yes, even if they're outside, even if you have an employee working in the middle of nowhere remotely from his cabin and he never sees anyone for the entire year, technically if he's working on or in connection with the contract, he must be vaccinated. For religious beliefs, can an employer ask for proof of participation from a religious organization, example, a church or a practitioner, etc.? Yes, you can ask for this. I will caution, however, that there is case law out there under Title VII that essentially explains that just because an employee isn't a member of a church or doesn't necessarily espouse the beliefs of that religious organization doesn't mean that they aren't necessarily entitled to an accommodation, or doesn't mean that they don't have a sincerely held religious belief. That blurs the line a little bit, but it's certainly on that list of things that you can ask an employee to help you determine whether they do have a sincerely held religious belief. So it's not off limits, but just because they can't provide it doesn't necessarily give you enough to reject the accommodation. Next question. This is a little bit of a long one. We are a small business, under 100 employees, doing business with the Army, both on-site and remote. First, do we have to provide weekly/bi-weekly testing options? So whether you have to provide this option will depend on a couple things. First of all, this is not an option for those who simply do not want to get vaccinated. If employees have a exemption under the medical accommodation or the sincerely held religious belief accommodation, then they don't need to get vaccinated. But everybody else still needs to get vaccinated, assuming that has been incorporated into your contract. For those unvaccinated individuals who do meet that exemption criteria, whether they have to get tested either weekly or biweekly will really depend on the Army's worksite requirements. For those on-site workers, the Army may well say, if you're unvaccinated and you come on site, we need you to show a negative COVID test. They're not going to have that testing requirement for your remote folks, so those remote folks would not need to get tested unless you have your own company requirements in place or a prime test company requirements in place. Okay, this is a second follow-up question to that. Would it be appropriate to tell all our employees and 1099 contractors that if they do not wish to get vaccinated to comply with the executive order, the only option we have available is to begin the termination process and remove the employee/contractor from their position? That would be a completely reasonable and appropriate response to employees who are simply refusing to get the vaccine and who do not submit an accommodation or do not receive an accommodation for a medical or religious accommodation. 1099 contractors are more or less in the same boat, with the exception that they're really, if they're performing work directly on a contract, they're going to be considered subcontractors. So for those 1099 consultants, really you should be flowing down the requirements to those contractors, to their contract, and then it's on them to comply. And if they're unable to comply or unwilling to comply, you should basically part ways with them and find someone else to do the work. I will mention that the guidance, as I mentioned earlier, I believe, does include some wiggle room potentially. It does sort of address this idea of progressive discipline, and maybe that January 18th deadline isn't a cliff. Maybe it's a little bit a softer landing that you can really encourage employees. Listen, you're not fully vaccinated, but if you get fully vaccinated in the next month, we're willing to continue to employ you on this contract. That might be sufficient. I would not be surprised if the government didn't update those requirements again by the 18th, but we just have to kind of wait and see. You mentioned that under the federal contractors law, there is no requirement for employees with an exemption to get tested. Does that requirement exist under the Biden law for companies that have over 100 employees? So the way that the OSHA ETS is drafted is that even if you're a company with over 100 employees, if you have a work site that's governed by the federal contractor mandate, then that means that the ETS, that OSHA requirement, does not apply to your work site. So for covered work sites where you have employees performing work on or in connection with a covered contract, they do not, they're not required to get tested, even if they have an accommodation. There's also no alternative for those individuals. They either have to get vaccinated or have an accommodation exception. But the silver lining is that no, those individuals who are unvaccinated with an exemption don't need to get tested. You don't need to provide them with the leave to get vaccinated, and some other of the reporting requirements are not going to apply because it is a federal contractor covered work site. I will mention that some contractors out there, some contracts have not incorporated the executive order into it, the 14042, which means that technically those work sites are not likely covered by the federal contractor mandate at this point. In that event, if you do have more than 100 employees and your contracts haven't been updated, the ETS likely would apply. So you just got to keep track a little bit of specifically which employees are governed by which requirements. I think the last two questions, and then we're almost done, and I think we're running up against our 5-minute mark, so this is great timing. If we fall under Executive 14042 as a government contractor, do the OSHA and other requirements apply? I just addressed this, but no. If you have a work site that is governed by Executive Order 14042, I think it's worth repeating because this has come up quite a bit. It's not going to be covered by OSHA. So again, silver linings, however small. Last question. We are a federal contractor. Just got one more, so I think we have time for these last two. We are a federal contractor, about 25 employees. We have no subcontractors, but we have about 30 consultants who range from quarter-time to full-time employment. How do the requirements flow down to consultants? So if these consultants are working directly on a contract, then they would be considered subcontractors, and you have an obligation to flow down to them. For those consultants who are only working the quarter time, they might not meet the simplified acquisition threshold. So if they're under that $250,000 mark for the life of the federal contract, chances are you do not have an obligation to flow down the requirements to them. But otherwise, assuming that they are working on the work under that performance work statement, then yes, they would be subject to the vaccination requirement. You don't have an obligation to observe their vaccine cards, but you do have an obligation to flow down the requirements. I'll also add that some agencies are asking for the vaccination status of employees and the accommodation status. In the event that your agency is asking for this information, you want to make sure that you get it from your subs simply so that you can pass it through to the government. And then the very last question that we have is, can a prime contractor require modification to a subcontract prior to the prime contract becoming a covered contract? Great question. This is really going to depend on the terms of your contract. If your contract says that the prime contractor can only modify the contract after it's been modified by the prime, then yes, they have to wait for it to be incorporated. But a lot of subcontracts out there provide additional terms where a prime contractor can modify. So you really need to look carefully at what those terms are to evaluate whether they have properly modified the contract. Okay, that is all of the questions that we have. I don't know about you, but I am tired of hearing myself talk.
Well, I want to say thank you, Sarah. And this was incredibly comprehensive. We're very, very appreciative. In fact, I'm going to ask everybody on the call who joined us today to join me in thanking Sarah Nash for this incredibly important presentation. All this information about employer liability for a vaccine enforcement, pretty critical. It's a big, big topic for our government contracting community. I want to thank all of our attendees, our VIP grads and our chamber members who joined us. We thank you so much for spending this time, your valuable time with us today on this subject. We look forward to you joining us for future EXCELerator programs, and we'll be sending out more information about upcoming programs to you soon. But until then, please join all of us in a great wishes for a happy Thanksgiving and a great holiday season, and we look forward to seeing you all again soon. Thank you again, Sarah, and thanks everybody for joining.
Thanks everyone. Thanks, Gigi. Bye.
Bye-bye.